Welcome to Claims and Sustains, a Seyfarth government contracts blog. I'm Zohra Tejani. In this episode, I break down what companies who do business with the federal government need to know about the FAR Clause on the Federal Acquisition Supply Chain Security Act, or FASCSA. This includes companies providing commercial products, commercial services, and even commercial off-the-shelf products. Then I close out with what to do after learning of a FASCSA order. So let's start with what is FASCSA and why does it matter? The Federal Acquisition Supply Chain Security Act of 2018, or FASCSA, was enacted to enhance the security of the federal government's information, communication, and technology supply chains. It established the Federal Acquisition Security Council, an interagency body responsible for identifying and mitigating supply chain risks posed by certain vendors and technologies. FASCSA authorizes executive agencies to issue exclusion and removal orders for products and services that pose national security threats. Let's walk through the scope of the federal acquisition regulation that implements FASCSA for federal contractors, FAR 52204-30. This clause applies to all federal contracts, including those for commercial products, commercial services, and commercial off-the-shelf products. This clause also is mandatory for commercial subcontractors. The rule prohibits companies from 1, providing or using any covered article or service from a source named in a FASCSA exclusion or removal order, and 2, continuing to use such items if a new order is issued during contract performance. So what are a contractor's responsibilities? 1, quarterly monitoring, so checking sam.gov at least every 3 months for new FASCSA orders. 2, track contractual requirements. There may be additional FASCSA orders that are not in sam.gov but were identified in a solicitation. 3, due diligence. Conduct reasonable inquiries to identify prohibited items. 4, report. So a contractor must notify a contracting officer within 3 business days if a prohibited item is discovered. There are nuances to this time frame and specific information that must be provided as part of that notification. 5 is removal. So for federal supply schedules, government-wide acquisition contracts, or other multi-agency contracts, the contracting officer may notify contractors that they must promptly remove any product or service produced or provided by a source that is a subject of the applicable FASCSA order. Flow down requirement: be sure to flow down the clause to subcontractors, but excluding the requirement to monitor sam.gov. So what should companies do once a FASCSA order is issued? So be sure to get legal advice on your specific situation, but at a high level, first thing is to analyze whether you're providing or using any covered article or service from a source named in a FASCSA exclusion or removal order. 2, work with your product engineering and or your procurement teams to exclude products and services from the entity listed in the order. 3, avoid using or supplying that entity's products in new or modified government contracts. And 4, conduct diligence and report any of those products in existing contracts. And then, if applicable, remove the product or service. So that's it for today's episode. I hope you found that helpful. You can subscribe to the Claims and Sustains blog so you can receive all future episodes of the Seyfarth Government Contracts Practice blog. Thank you.